Let me be very clear. Most people think hearings are where decisions are made, and they're wrong. By the time you walk into a family court hearing, the decision is already half made, sometimes more than that. And the thing that shapes it, it's not your passion, it's not your evidence bundle, not how reasonable you sound, it's the skeleton argument. And here's the truth that nobody tells litigants in person. Judges don't decide cases in hearings. They confirm decisions they've already made. They've mapped them out on paper. The hearing is often just a theatre. The skeleton argument is the script. What a skeleton argument really is, now people call it a summary. That's nonsense. A skeleton argument is a thinking shortcut, a risk filter, a decision map. Judges are overloaded. They are tired. They are managing risk, time, and appeal exposure. So they rely on whatever document lets them decide quickly and safely. That document is the skeleton. If your skeleton is weak, confused, emotional, or rambling, nothing you say orally will rescue you. This is the mental question the judge is asking before they've even sat down. The judge is asking, what is the safest, quickest, least appealable decision I can make today? Your skeleton argument either answers that question for him or her, or leaves them to answer it themselves. If they answer it themselves, you've already lost control. For me, there's a 4-part skeleton that actually works. There are only 4 components that really matter. Anything else is noise. Firstly, the issue. 1 paragraph, no story, not background, not history, not grievance. 1 paragraph that answers this. What decision does the court need to make today? For example, the issue for the court is whether interim supervised contact should continue, or whether a structured progression to supported contact is proportionate, given the absence of current safeguarding concerns. That's it. If the judge can't repeat your issue back to themselves or you in 1 sentence, you failed. You failed straight out before you've even, it's non-starter. Number 2, the legal framework. Now, this is minimal surgery. You are not teaching law. You are signaling competence. You list the statute, the practice direction, the principal example. Children Act 1989, Statute 1, welfare checklist, proportionality, practice direction 12J, if relevant. No lectures, no case law essays, no showing off. Judges don't reward clever, they reward usable. Thirdly, you've got the risk analysis. This is where you win. Now, this is where amateurs collapse. They argue their pain. Professionals argue institutional risk. You are not saying this is unfair to me. You're saying this exposes the court to risk if it continues. For example, maintaining supervised contact in the absence of current safeguarding concerns, risk entrenching interim arrangements into a de facto final position, contrary to proportionality and the child's welfare. That sentence speaks the judge's language. You've just made change safer than inaction. Number 4, the proposed order, judge ready. This is where you take control. You draft numbered, clear, copy and paste ready. Example, contact to progress from supervised to supported within 28 days. 1 supported session to be observed by CAF. Review hearing listed in 6 weeks. Liberty to apply. Judges love this because it reduces their cognitive load. You've just done half their job for them. Why most people lose, even when they're right? Because, well, they over-explain. They re-argue history, bury the issue, write emotionally, forget risk. They think persuasion wins cases. It doesn't. Clarity does. The coach in truth for this is, if your skeleton argument is good, the judge interrupts you less. The hearing is shorter, loses. The CAFCAS loses narrative dominance. All submissions barely matter. And if your skeleton argument is bad, or you're fighting an uphill from there, from the first sentence. This is why experienced advocates seem calm. They've already won on paper. No, so the practice task is you're going to need to do this properly. Draft a maximum 2-page skeleton argument for your next hearing using this structure: issue, legal framework, risk analysis, proposed order, and rules. You've got 30 minutes only. No emotion, no backstory. Just read it out loud. If it sounds defensive, cut it. If it takes longer than 3 minutes to read, it's too long. And what you need to remember is this: family court is not won by who speaks best. It's won by who makes the best, who makes the decision easiest. And scheduling arguments are how you do that. Not, So you've put day 16, is this day 16? So maybe it's day 17 soon. Maybe I'll see you soon. Day 17 is coming.